Well, thank you everyone for coming along to this buy-to-let properties possession pitfalls seminar. There's just a couple of points I wanted to go through first, and then I'm going to sketch out why it is we're doing this seminar and what the current state of play is with recovering possession, and particularly Section 21 notices. And I'll introduce then the speakers before we go through their talks, and then conclude with a Q&A session at the end if anyone's got anything they want to ask. So a couple of housekeeping points first. This session is being recorded, and following its conclusion in due course, the recording will be put online and made available to everyone who attends. And as well as that, the slides that the delegates, that the speakers are going to be using will be sent out to the delegates, again, in due course. So you can look forward to those. The other housekeeping point to make is that there is, if you look at the bottom of the screen, a Q&A function that Zoom has. That's separate to the chat function. The Q&A function will raise questions that only we can see. And I would encourage you, if you have any questions at all during any of the talks, to put those questions in the Q&A function. And then at the end, we can collate any questions that we've got and we can work through them. So I just wanted to speak briefly before we get to the meat of this on really why this seminar is topical at the moment. And it's to do with where we're at with Section 21 notices and recovering possession in the private rented sector. This is something that has been kicked around for an awfully long time. And actually, as far back as 2014, the government at the time was making noises about improving security of tenure for assured short-hold tenants. And that included the provision of a model AST agreement that landlords were encouraged to use, that included a minimum fixed term of 3 years, along with, in later revisions, a 6-month break period. So even as far back as that, the Conservative government was looking to improve the security of tenure for assured short-hold tenants. But we can then fast forward to April of 2019, when the government published a paper at that stage setting out a recommendation for bringing to an end the availability of Section 21 notices to end tenancies on a no-fault basis. Now, that was going to be accompanied by a proposal for additional grounds for possession under the Section 8 process, including, probably most radically, an additional mandatory ground for possession that could be used in circumstances where the landlord wanted to sell the property. However, that would have required, as with some of the other mandatory grounds, a pre-tenancy notice that the ground could be relied on, and more importantly, the minimum term of the tenancy before that notice could be used was a 2-year term. So even then, there was a considerable strengthening of the tenant's rights. Going forward a little further then to 2021, the Queen's speech, I think for the second time, committed to ending Section 21 notices, along with an intention to hold a consultation on, or to respond to an ongoing consultation on the end of Section 21 notices. Now, that consultation was supposed to conclude last year. It's been kicked into the long grass a little bit, and it's looking like there's going to be the government's response to the consultation at some point this year, but we don't know when. You might have thought, against that background, with continuing commitments to end Section 21 once and for all, that during the pandemic, that might have been the prime time to do it. And in fact, in both May 2020 and March of 2021, the HCLG Select Committee recommended fast-tracking the legislation to do it, spurred on by the pandemic, and to once and for all end Section 21 as an option. But that didn't happen, as we all know. And instead, we had this hodgepodge of amendments to the legislation to make Section 21 more painful to use, but still available. So where we are at the moment is we just don't know what's going to be happening. We know that the government response to its long ongoing consultation is going to be provided later this year. We know that there have been manifesto commitments and Queen's Speech pledges to end Section 21. So that's a good indication of what the government's response might be. But on the other hand, they've had a perfect opportunity over the last couple of years to do it and haven't. So we have uncertainty. The only things we do know at the moment in terms of private rented sector are that house prices are at an all-time high. We know that that's probably a bubble. We know that cost of living is in a horrific state. And we know that there is a potential for Section 21 to come to an end, which even if the housing market the housing market bubble doesn't burst, that will probably cause the buy-to-let market to burst around that time, once that commitment is made by the government to finally bring Section 21 to an end. So what we can assume going forward is that clients may well be looking to liquidate their investments in the private rented sector. They may well see the way the wind is blowing and realize now's the time to free up those assets. And that means they're probably going to be doing it with vacant possession, and so are probably going to be serving all sorts of notices. Now, we all know they're not going to come to you prior to taking all of those steps. The ones that are going to be difficult are the ones where the landlord client has already taken the steps, has already served notices, has maybe even issued proceedings, and then things have started to go wrong. So the purpose of this seminar is to really look at some of the technical issues that clients in that situation will find themselves in, the sorts of things that we should be on the lookout for, identifying them as soon as possible, and maybe dealing with them before the matter actually gets to court. So a little out of the build order, we're going to be starting with Harry, who's going to be talking about the prescribed requirements before Section 21s can be served. We're then going to move over to Priya, who's going to talk about tenancy deposits and all of the fun they create. And then we'll finish with Alex, who's going to talk about HMOs and what happens when there are issues with particularly licensing. And then we'll round up again with a Q&A at the end. So I'm going to pass over to Harry, who's going to kick us off with prescribed requirements.
Good afternoon, everybody. I hope you can hear me. For those of you that don't know me, I was called in 2018. I undertook pupillage at St Ives Chambers, and I've been a tenant since 2019. As David says, I'll be talking about the prescribed requirements to you, and what we'll start with is a very brief summary. Now, before we go into that, if I can just extend David's hypothetical scenario, the prescribed requirements are quite technical, they are quite legal, and simply talking through them probably isn't going to help you very much. So let's instead try to put some context on it. Let's imagine that a client has come into your offices. They own a relatively small buy-to-let property portfolio, perhaps less than 10 properties. As David says, they know things are on the horizon. They're seeking to obtain vacant possession, and they want to liquidate their assets. Now, what we need to consider very briefly are what their objectives are. And as with any client, they are primarily threefold. They want the order that they want it quickly, and they want it at the lowest possible cost. Now, because of those objectives, it's probably going to inform how we talk about the prescribed requirements. It may be the case that the landlord has taken some steps, as David says, but when we're looking at the prescribed requirements, we need to very much look at it in a three-stage approach. Firstly, what is it that the landlord is required to do? Secondly, if they have not done so, can it be remedied? And thirdly, if it can't be remedied, what are the other options? So that's the three-stage process that I want to sort of frame my little discussion about the prescribed requirements towards you, and hopefully we'll see that process through as we move through the slides. Now, just very briefly, I'm sure all of you have heard of the prescribed requirements, but they are effectively becoming relevant as a result of the Deregulation Act 2015. That has made some changes. Namely, it has prevented a landlord from serving a valid Section 21 notice at a time when the landlord is in breach of those prescribed requirements. And that applies to both Section 21.1 and 21.4, both subspecies of the Section 21 notice. And as I've said in that first bullet point there, it's applied to all ASTs from the 1st of October 2018. We'll come on to touch upon some positions before that date. I think it's probably quite unlikely that many clients are going to be having 4-year plus ASTs, but we never know. And we are effectively focusing on three prescribed requirements, 3 traps that our fictitious landlord can fall into. First, relating to an energy performance certificate. Second, relating to a gas safety certificate. And finally, this document that's called the How to Rent, the checklist for renting in England. You all have seen it. I'm sure you don't want me to keep repeating that lengthy title, so I'm just going to be calling it the How to Rent booklet as we work through. Now, before we can look at precisely what is required of our fictitious landlord, I think we need to look at the legislative basis that's behind those requirements upon him. Now, this is quite technical, so I've included the various subsections into the slide. I don't think you're going to find it particularly interesting if I just read it to you, but it's there to follow through. Now, the reason why I say it's particularly technical is we have a statutory basis followed by a set of regulations that then take us to a further set of regulations. So on that 3-stop tour, let's start at the Deregulation Act 2015. Relevant sections are 38 and 39. You'll see them there. You can read them yourselves. And as I say, Section 38 is introducing this new Section 21A to the Housing Act, and it prevents that Section 21 notice from being served at the time we are in breach of the prescribed requirements. Very quickly, if I could just flag subsection 2 for you at the bottom of the slide, that gives an insight into the intention of Parliament in bringing in this new act. Effectively, we're trying to ensure that those in the private rented sector are in good quality houses that ensure they are safe, the tenant is safe, and they are energy efficient. Section 39 gives a little bit more detail, a little bit more flesh on the bone. It tells us that the Secretary of State can create these statutory instruments that set out the prescribed requirements. So the door's open to more, I suppose, down the line, but just know that that's what takes us to the second stop, which is our first relevant set of regulations. Now, these are the assured short-hold tenancy notices and prescribed requirement regulations. It is a little bit of a mouthful, but as I say, this is effectively the signpost that takes us to the sub-regulations, as I'll call them, the next set of regulations that actually tell us that which we have to do. So Regulation 2 takes us to 2 set of regulations. Regulation 6.5 of the Energy Performance of Building Regs. So that's the one relating to the Energy Performance Certificate. And Regulation 36 of the Gas Safety Regulations. That's the one related to the Gas Safety Certificate. Yeah, sorry this is getting a little bit dry already, but we'll move on quickly. We're just going to power through it. So regulation of those, that first sub-regulation takes us to the How to Rent regs. So let's move on. I've just put a slide there which actually takes you to the How to Rent booklet. Copy and paste the hyperlink to get to it, but I thought it might be helpful if it's just there. Consequences of non-compliance, we've touched on this already before. It is given by Section 39 of the Deregulation Act. If we aren't, at a time we're in breach with those prescribed requirements, we can't serve our Section 21 notice. And as we'll come on to discuss, that wording of Section 39 is particularly significant. Now that's the context. Just note two things there. Firstly, there are some instances that can be remedied. Secondly, there is that case of Minister and Hathaway, which sort of suggests that 1st of October tenancies granted or renewed after that date, on that date, before that date, there's no requirement to serve the EPC. So although we are primarily talking about post-2018, there are limitations to the requirements for these earlier tenancies. If there's going to be wider application of the principles in that case to matters outside the EPC, perhaps to the gas safety certificate or to the how to rent booklet, that's an argument for another day. Well, I'm sorry I've bored you with those slightly technical points, but let's get in to what the regulations actually require. Let's look at each of those pitfalls. We're just going to power through this because it's largely written on the slide. Let's start with the Energy Performance Certificate. Regulation 6, subsection 5, requires that a valid certificate be given free of charge to the person that ultimately becomes the buyer or tenant. We're looking at tenants here, of course, but that's the phrasing there. I've made a little reference to the energy efficient regulations. Those are not a prescribed requirement and do not create a trap that prevents us from using the Section 21 notice. But just note that they exist. It sort of ties quite cleanly to the Energy Performance Certificate. Now let's take it back to our fictitious landlord that's come in. He may have taken some steps himself to start the possession process moving. What is it that the landlord should or should not have done as we move into the issuing status for the EPC? And I've just flagged there that if you're using Section 21, you're of course going to be using the accelerated possession procedure. And so the EPC should be attached to that pro forma N5B claim form and marked F. Next thing we've got is, of course, the gas safety certificates. You'll see that it's Regulation 36, and particularly we're looking at paragraphs, subparagraphs 6 and 7. They draw a distinction between properties that have a gas fitting inside of them, and there are different requirements depending on that. So 6 deals with where there are, and as you can see there, a copy of the gas safety certificate needs to be given to the tenant before they take up occupation, and each time there's a check, they need to be given the new copy. Position slightly different when there is no relevant gas appliance within the property itself. Think, for example, a block of flats where there is a communal boiler, for example. And as you'll see there, the position is slightly different. The gas safety certificate has to be displayed in a prominent position and a copy provided on request. Now, one little thing to note about the wording of paragraph 6 there is it says the copy has to be given within 28 days of the check. Well, let's go back to the first set of regulations we looked at. Regulation 2.2 says that 28 time limit doesn't apply in this context. Note also that if we are using the accelerated possession procedure, again, we're going back to our fictitious landlord. Claimant form M5B is absolutely clear that we need to append those gas safety certificates, not only the first one, but those that followed, and that needs to be marked paragraph G. And there's a lot of information that we need to put in that N5B claim form, the date of issue of those gas safety certificates, and when they were actually given to the tenant. So we've done the first 3 prescribed requirements. We've looked at what is actually needed. Let's move on to the third and final one that we'll be looking at, and that's the how to rent booklet. As you'll see there, Regulation 3 requires us to give a copy of the most recent version to the tenant. Couple of points to note on this one. What is not required, each time a new version of the booklet is published, we don't have to give that new version to the tenant. And there's a very specific example there about replacement tenancies. That's somewhat limited, but I've just flagged it there for your attention. Now, one of the things that's not entirely clear is if we have to comply with this requirement for ASTs that were granted before the 1st of October 2015. Now, the reason why that's not entirely clear is the booklet didn't exist at that time. If you want to take a belt and braces approach, we may want to serve a copy of that how to rent guide, give it to the tenant before we serve our Section 21 notice. There's also a slight additional complication in that we now have a new version of the document, well, it's an accompanying document, which is the How to Rent Easy Guide, Easy Read version. Now, this was described as being supplementary, and it was intended to be given to tenants who have got learning disabilities. Now, it doesn't appear to be the case that we have to serve that easy read guide or will be prevented from using a Section 21 notice. It seems to be the case that we have to provide the normal version of the booklet in all circumstances, save for the exceptions on the previous slide, and then the easy read version in addition to that in cases where the landlord considers it to be appropriate. Note again, if the landlord has taken some steps himself, when that claim form is done, a copy of the How to Rent booklet should be attached to the claim form and marked with an H. So that's what we need to do. Let's imagine it's not been done. Now, the question that then arises is, can that be remedied? And the key case there is the case that appears on the first bullet point, and it's the Tree-Carrell case. And what that effectively found is that where a gas safety certificate had not been provided before the start of the tenancy, a Section 21 notice can still be served if you remedy that breach. If you give a copy of the gas safety certificate before the Section 21 notice is served, it will be a valid Section 21 notice. And the Court of Appeal helpfully provides some clarity on that case. I won't go through the judgment in its entirety. You've got the link there. I definitely think it is worth reading. But what's probably also worth looking at is the position before Tree-Carrell and the clarity that provided. Now, the main decision before that was a decision in a case called Carradon Property Limited and Schultz. It was a county court decision before His Honour Judge Luber QC. In effect, it found the absolute opposite way to Tree-Carrell. And I think there is an important point here, which is looking at the focus of the respective courts in reaching their decision. Now, in the Carradon property case, the focus of His Honour Judge Luber QC was very much on the reasons for the gas safety regulations in the first place. And particular focus was placed on the fact it was to ensure properties were safe, it was to ensure that tenants knew they were safe, and it was to ensure that checks happened at regular occasions to keep the property in that state of safety. And His Honour Judge Luber QC's view was very much that if we can remedy the failure to provide a gas safety certificate down the line, the protection intended by the regulations, the gas regulations, would simply be averted. And as I say, Tree-Carrell found the other way, and that is the relevant authority that we are to focus on now. And the focus in that case was very different. The focus in that case was on the construction of Section 21A of the Housing Act 1985. That being inserted by the Deregulation Act. And you'll see there I've highlighted the relevant parts of Section 21A. And it says there that a Section 21 notice cannot be given at a time when the landlord is in breach of a prescribed requirement. So if the time of breach comes to an end, the sanction, the bar to a Section 21 notice falls away. Now, I imagine that a central plank of the Court of Appeal's reasoning in that case was a public policy consideration. It was effectively to allow Section 21 notices to continue to have some value, and it was not to put only overly onerous security or tenure as a result of that Section 21 embargo. I think it should be noted that in Tree-Carrell, the gas safety certificate had actually been obtained, and it was simply an omission to give it to the tenant. Now, the position may be slightly different if there was no gas safety certificate before the tenant took up occupation. And also note that this authority only discussed gas safety certificates. There are no definitive authorities in relation to energy performance certificates or the How to Rent booklet, but one would hope that if you can rely on the reasoning that we've discussed just now between how the Court of Appeal came to its decision, it can be applied by analogy. Now, it's not a published authority, but I had an appeal on this point in a couple of weeks ago, which concerned where a how to rent booklet had been served at the same time as a Section 21 notice. The case evolved slightly as it moved along, and it turned out that a how to rent booklet had actually been given to the tenant about an hour before the Section 21 notice was served, along with at the same time as the Section 21 notice. There were two how to rent booklets that were given. And the court focused very much upon that reasoning that was given in Treacle. It was this idea that what we need to be looking at is the time. Are they in breach at the time the Section 21 notice was served? And we were successful on our arguments. The court agreed with us that that was the central focus. Now, unfortunately, I can't give you an authority that makes that binding. It was only a circuit judge decision, so it doesn't have that same force as the Court of Appeal one. But hopefully that's a little example for you that if you understand the reasoning behind the case, we can bring it on to the other prescribed requirements. So let's imagine a scenario then where our landlord has issued, based on a Section 21 notice, where they were in breach of prescribed requirements. Unfortunately, it's already too late to remedy it, or perhaps we're in a position where the landlord doesn't want to take the risk of running that Treacle arguments. So what else can we do? Well, the first option is probably a slightly obvious option, which I think David sort of covered in his intro, which is we could simply remedy it, serve a new Section 21 notice, and then pursue a claim on the basis of that. Well, if not, what else have we got? And I think we need to remember that an assured short-hold tenancy is, of course, a subspecies of an assured tenancy, and those assured tenancies can be ended by the use of a Section 8 notice. So we can still use Section 8 instead of Section 21 for ASTs, and this is something that we need to have in our minds when we're advising clients. I don't intend to go through this in much detail. I'm sure you're aware of the distinctions and the intricacies of the Section 8 process, but let's just power through. There are in effect a distinction between two circumstances: mandatory grounds and discretionary grounds. I've set out the mandatory grounds there. I think it's worth reading them in full, but those are a summary. And in short, if the mandatory grounds made out, a possession order will follow unless there are some sort of convention rights arguments that can be run. Very briefly, let's look at the discretionary grounds, because these might allow us in a little bit more. They're there in full. I think it's going to be 10, 11, 12, and 14 that are likely to be the most relevant. And just note, unlike the mandatory ground and the discretionary ground, the court will go on to consider the question of reasonableness, and the tenant may also ask for the order to be suspended rather than immediate. Form of a Section 8 notice, it's tenancy form 3. Just note there have been some changes about the extent of the notice. As of the 1st of October 2021, we're back to 2 weeks. So final conclusions. What advantages do we have of a Section 8 over a Section 21? Used to end the AS2 during the fixed term, arguably fewer technical requirements, and unlike a Section 21 accelerated possession claim, we can bring a money judgment. Disadvantages: we need to make out a ground for possession. It may not necessarily be there for our fictional landlord. We need to satisfy the court of reasonableness, and we can't use the accelerated possession procedure, so it may be a little slower. So thank you all for listening. I think at this stage I've gone slightly over my allotted time. So I'm going to hand over to Priya Tromans, who I think is going to be discussing tenancy deposit requirements. Priya, I don't know if you're there, but I'm going to stop sharing my screen now. I'm going to hand over to you.
Thank you, Harry. I'm going to share my screen now, and hopefully you can all see that. So this section of the seminar will focus on the initial advice that should be provided to your landlord clients in relation to their obligations with regards to tenancy deposits. So what constitutes a rent deposit? Generally, a deposit will be recognisable as such, being a lump sum described as a deposit, usually in the AST, which the tenant is required to pay before the keys are handed over and the tenant can move into the property. But sometimes there are things that have money that has been taken as security, which also can be termed a deposit. My advice would be to be alert to any money that's taken for the landlord as security for the tenant's liabilities in connection with the AST. That may constitute a deposit and therefore has to be protected in a tenancy deposit scheme. So the following may be caught as deposits. So a fee described as a cleaning fee, which is paid by the tenant in advance, but is repaid to the tenant at the end of the AST, if or to the extent that the property is clean and does not require the cleaning fee. Additional money charged as rent each month, which is collected by the landlord, perhaps to offset against potential costs of repair or cleaning again, will still be a deposit if it's not described as such, even in the AST, and there is a clear provision to be repaid to the tenant at the end of the term. So what about advance rent? This has come up a few times, I think, for most people. And in Johnson and others, and old, the Court of Appeal indicated that a genuine advance payment of rent did not constitute a tenancy deposit. For a payment to amount to a tenancy deposit, it has to be made as security for either the performance of the tenant's obligations or the discharge of any liability arising under or in connection with the relevant tenancy. The court stated there's a difference between money paid to discharge an existing obligation and money paid as security for the obligation. A genuine advance payment of rent is the former, i.e. money paid to discharge an existing obligation. There is an unreported case from Grimsby County Court of Piggott, and in that case the court stated that whilst each case has to be considered on its merits, the requirement in Piggott for the tenant to pay monies to be held against rent due in the last 2 months of a tenancy was in effect a requirement to pay a deposit and therefore required protection. So the requirements for your landlord when he receives his deposit, the deposit must be protected. There are 2 things that he must do within 30 days of receiving the tenancy deposit. First, he must protect the deposit in an authorised tenancy deposit scheme. Upon protecting the deposit, the landlord will receive then a deposit protection certificate. And he also must give to the tenant prescribed information concerning the operation of the scheme and the tenant's rights and remedies. But what happens if he hasn't protected the deposit or hasn't protected the deposit within the relevant time period? So no Section 21 notice if the deposit is not held in an authorised tenancy deposit scheme, Section 2151 of the Housing Act. So if the tenancy deposit has been paid in connection with an assured short hold tenancy, the landlord can't serve a Section 21 to recover possession if at the time the Section 21 notice is served, the deposit is not held in accordance with an authorised TDS. But the Housing Act does say that the landlord can serve a Section 21 notice once action has been taken to rectify the situation, similar to the remedies that Harry was talking about earlier. In order to remedy the situation, the landlord would have to repay the deposit, whether in full or with agreed deductions, or following determination, settlement, or withdrawal of any claim under Section 214. The exception to this is where the deposit was received before the 6th of April 2007, and a statutory periodic tenancy arose before the 6th of April 2007. In that case, the landlord can protect it late instead of having to repay it. Another consequence of failure to protect the deposit, other than not being able to serve a Section 21 notice, is the issue of compensation for the tenant. So where a landlord fails to comply with either or both of the deposit protection obligations, the tenant can make an application to the county court under Section 214. The claim can be made whether or not the tenancy has ended. And if the court is satisfied that the landlord has failed to comply with its obligations, the court must, if the tenancy is ongoing, either order the deposit to be repaid or for it to be paid into an authorised scheme. If the tenancy has ended, the court has a discretion as to whether to order the deposit to be repaid to the tenant, and if so, whether to order full or partial repayment. In either case, the court must order the landlord to pay the applicant a sum of money not less than the deposit amount, but not more than 3 times the deposit, and within 14 days of that order. This is termed statutory compensation. And the court, in deciding how to award the statutory compensation, has regard, as usual, to many relevant factors, but the primary focus is on the landlord's culpability. In other words, the seriousness of the landlord's failure to comply with his or her obligations. So you may ask, can the tenants claim multiple breaches of deposit legislation? Well, cases that have gone to court have attempted to claim for breach of the deposit legislation against the landlord or agent for each and every tenancy that was renewed, or that have breached both protection and not serving the prescribed requirements. Most of these have failed, and the intention when creating the deposit legislation was not intended to give the tenant a windfall, and therefore it is generally termed one penalty for one tenancy. There is an unreported case of Howard and Dalton in the county court. You don't have it on your screens. There is a link to it shortly, but I'll just read out the relevant point. A failure to protect under Section 2133 would inevitably give rise to a failure to provide prescribed information under Section 2136. It was not Parliament's intention that damages should be awarded for each breach rather than only either breach. The requirement to provide prescribed information could not be independent of the requirement to protect. The penalty was therefore one penalty for one tenancy. What if there's more than one tenant? I've put an example up on the screen for, it might help to work through it. So there's more than one tenant. The landlord, your client, grants an AST of a flat to 4 tenants for 1 year. Tenant 1, T1, pays the deposit to the landlord. This is the only deposit paid, and presumably the other tenants reimburse T1 a proportionate share of it, we're going to assume. In breach of his obligations, the landlord protects the deposit late, so after the 30-day period has expired, and he doesn't serve the prescribed information. The first tenancy expires, a second fixed term tenancy is granted, and then one of the tenants changes. The second tenancy expires and becomes periodic. The tenants change again. Only T1 remains in occupation throughout the original deposit, throughout the tenancy, and the original deposit simply continues to be held in the original scheme. So in this example, who ought to be claiming for compensation under Section 214? T1's various co-tenants should either be parties to the claim or give T1 their express authority to conduct the proceedings on their behalf. Section 214, again, I don't want to get too technical, but Section 214(1) of the Act requires the application to be made by the tenant. Section 6C of the Interpretation Act 1978 provides that words used in statute in the singular include the plural, unless the contrary intention appears. There's no contrary intention in Section 214 or its surrounding provisions, so the reference to tenant or applicant must be read as referring to tenants collectively, in circumstances, obviously, where there is more than one tenant in the tenancy agreement. At the very least, this must be the case where one deposit is paid in relation to the tenancy as a whole, as opposed to each tenant paying their own deposit. There on the screen is the reference to that unreported case. The penalty was therefore one penalty per tenancy. So continuing with tenants as co-claimants, this happens fairly frequently for buy-to-let landlords as they buy for university share occupants and college attendees, and it's sometimes the best way for them to make the most money out of their buy-to-let properties. Gladhurst and Hashimi, 2011, found that it was common ground that an application under Section 214 was required to be made by all tenants as co-claimants. Lord Justice Patton, in his judgment, approved of this, and but albeit in this particular case, it was held to be properly constituted by the sole claimant because they had acquired the co-tenant's consent to continue. In other cases, the same legal position has been accepted by district judges. So rather than strike out the claim, the court will accept an undertaking by, for example, in our example, T1, to share any award of the compensation between herself and her co-tenants, and in shares to be determined between themselves. In the Gladhurst case, it was ordered that T1 take all reasonable steps to join her co-tenants to the claim, or alternatively to procure their authority to conduct the claim, or alternatively to claim on their behalf within 14 days. So the advice for landlords faced with a claim for compensation brought by one tenant in the context of multiple co-tenants, I would advise you to write to T1 or her solicitors and invite T1 to join all her co-tenants as co-claimants to the claim. Failing that, invite T1 to procure the express authority of her co-tenants to conduct the proceedings on their behalf, and then require T1 to give an undertaking to share any award of compensation with those co-tenants. Put T1 on notice that if she fails to do so, an application will be made to strike out her claim. And if she doesn't yield, make the application to strike out her claim. But obviously, if a favourable costs award is obtained, we can always use this as part of settlement negotiations. So the importance of ensuring that claims for statutory compensation under Section 214 are dealt with in this manner is that it aims to prevent successive claims by each co-tenant, each claiming between 1 and 3 times the amount of deposit paid on behalf of all of them. It could obviously hugely inflate the landlord's liability. If all tenants are joined to the claim as co-tenants or co-claimants, at the very least authorise one to obtain an award of compensation, any attempt by others subsequently to bring their own claim for compensation in relation to the same deposit would be an abusive process or else precluded by a cause of action estoppel. So are there cases in which the deposit should be reprotected? In the TDS insured for landlord scheme, if the tenancy enters a new fixed term, the deposit would need to be reprotected and the protection fee paid again. For example, if the tenant didn't want to move to a periodic tenancy, but instead wanted to remain in the property for another fixed term of 1 year, then the landlord would need to re-protect the deposit. The case of Superstrike and Rodriguez decided that a statutory periodic tenancy was a new tenancy. This has been addressed by the Deregulation Act. The issues of deposit within the Deregulation Act are referred to at sections 30 to 32. Essentially, if the deposit was received on or after the 6th of April 2007 and was protected correctly at the time, the deposit does not need to be re-protected, nor the prescribed information served again on renewal, as long as the tenant, the landlord, and the premises remain the same, and the deposit is held in the same scheme. And the prescribed information can include details of a person representing the landlord. And there are 4 situations where the prescribed information needs to be reissued: change of tenant, change of landlord, change of scheme, for example, insured scheme to the custodial scheme, and of course, change of tenancy address. So if your landlord has an alternative property for the tenants to move into. Sturgis and another body is another His Honour Judge Luber QC case. It was held that where the identities of tenants in a house share change by way of surrender and regrant, and the vacating tenant's deposit is reimbursed directly by the incoming tenant, the deposit held by the landlord is having been treated as being paid by each new tenant. Therefore, the deposit should be registered as and when the new tenancy arises. This is another dry bit in relation to the Deregulation Act 2015. Again, I'm not going to read all the way through it, but just to alert you to the relevant sections of the Housing Act. There is an extended period in which to comply under section 215A. The requirements apply to any of the original deposit which continues to be held in connection with the periodic tenancy, and to any additional deposit which the landlord may have received in connection with the tenancy. Where at March the 26th, 2015, the landlord no longer holds any deposit in connection with the periodic tenancy, or the tenancy has ended, the landlord will be treated as having complied with the requirements in section 213 of the Housing Act. So what about renewal ASTs or statutory periodic tenancies arising on or after April 2007? Where the deposit has already been protected and the prescribed information has been given, then if a renewal AST or statutory periodic tenancy arises on or after the 6th of April 2007, there is no need to serve the prescribed information if the tenancy remains protected within the same tenancy deposit scheme. Some commentators had thought the effect of Superstrike was that every time a tenancy became a statutory periodic tenancy or was renewed, it would need to be protected again and prescribed information given. This is no longer the case as a result of section 215B of the Housing Act, which was inserted by section 32 of the Deregulation Act 2015. Lastly, the new section 215B covers cases where a landlord receives a deposit on or after the 6th of April 2007, which could be at the start of a brand new tenancy or at the start of a renewed tenancy, and subsequently protects that deposit and sends the required information to the tenant. So joint tenancies. In a joint tenancy, all tenants are jointly and severally liable for the obligations of the tenancy, for example, paying the rent. And as long as the termination provisions set out in the AST are followed, any tenant can give notice to leave the property. If the contract says 2 months' notice is required, any tenant can give this notice and move out 2 months later. But at this point, the tenancy will have ended for all parties, unless the tenancy agreement says otherwise. It won't simply be business as usual, since the tenancy that previously existed, along with its terms, has terminated. That's another example to illustrate this point. So one tenant wishes to leave midway through a joint tenancy and has located a replacement tenant. The parties agreed that a change of tenants can take place rather than insisting all tenants vacate. The landlord or agent should collect the appropriate share of the deposit detailed in the tenancy agreement, or where it's not specifically stated in the tenancy agreement, the amount should be proportionate to the number of tenants. And if that's not the case, that should be clearly documented. A new tenancy agreement is drawn up for the tenants who will be in occupation to sign, including the new incoming tenant. Obviously, your clients ought to be aware that by creating a new tenancy, you will be giving the tenants security of tenure for a further fixed term. An individually negotiated clause is added to bind all the tenants to the inventory for the original tenancy, with a date specified as to when the inventory was produced. Then the incoming tenant is advised in writing that this means that their deposit will be based on this document. The tenancy deposit scheme recommends that the rent account is also brought up to date before the swap takes place. The outgoing tenant should be asked to sign a waiver confirming that they have received a refund of their entitlement to the deposit under the first tenancy. They relinquish any claim to the deposit for the new tenancy agreement, and the agreed sum is released to the vacating tenant. The deposit protection for the original tenancy agreement is ended on the TDS database, and the deposit for the new tenancy agreement is registered and a certificate issued to the tenants along with revised prescribed information. That would be in an ideal world, obviously. Before we go on to this slide, just a quick word on agents. There is a case, Draycott and Hannells, where the High Court held that if an agent receives a deposit and fails to protect it, the tenant can bring proceedings against the agent for a penalty. Just to bear that in mind. Problems arising then on transfer of a landlord's interest. So where a landlord has not complied with its obligations relating to a tenancy deposit, and then he wants to transfer his interest, he or she can return the original tenancy deposit to the tenant before transferring its interest. This will allow the new landlord to serve a Section 21 notice on the tenant. Alternatively, another practical piece of advice might be that if the new landlord inherits the original tenancy deposit, it could ensure that the sale contract provides for an indemnity from the old landlord in the event it wishes to take back possession in the future and must return tenancy deposit to the tenant in order to serve the Section 21 notice. So the solutions. If your landlord client has failed to protect the tenant's deposit in an authorised TDS, or failed to protect it in time, or has failed to serve the prescribed requirements, it has then the following options. Service of a Section 8 notice. Harry went through the advantages and disadvantages of serving a Section 8 notice as opposed to a Section 21 notice earlier. You can return the deposit to the tenant, service of a Section 21 notice, and issue of proceedings under standard possession procedure. provide the prescribed information, and return of the original tenancy deposit where a landlord is transferring its interest. That was the situation I just described when the landlord wishes to sell the property to a new landlord. So that's tenancy deposits, a quick whirlwind whistle-stop tour. I'm going to hand over now to Alex Pritchard-Jones to discuss HMOs.
So as I was preparing this, I was reminded that actually my first ever case as a pupil barrister on my feet was about HMOs. I was defending a woman accused of running an unlicensed HMO, and she was in Birmingham Magistrates Court to be prosecuted. She had to plead guilty because, as you'll see, there are very few defences. I was quite nervous. And as I summoned up my powerful mitigation about how contrite and sorry she was, the magistrate stopped me on word 3 to tell me that my client was chewing gum and that I needed to tell her to stop chewing gum. So it was a bit of a rude awakening to HMOs and making sure your client doesn't chew gum in court. So the reason I decided to do this topic is because it's very interesting, I think, and it remains a huge potential pitfall for buy-to-let investors, because as you'll see, almost all houses or flats can be houses of multiple occupation. And if you operate one without a license, or you operate one with a license, but don't do what you need to do in accordance with the license requirements, you can get a big fine. So here's an example of someone from Birmingham, Spark Hill. He had a HMO, house of multiple occupancy or occupation, and he got fined thousands of pounds for running it and having all of these issues in it. So that's why it's interesting and it's important to your clients. So here's some statistics or some facts. Since 2014, the number of HMOs in Britain has more than trebled. I got that from 24 Hours in Police Custody on Channel 4. And in essence, where a house is occupied by more than one household, it may need to be licensed. Now, the general rule is it's over 5, but what you should have in your mind when advising your clients is there more than one household in here? Because that will really determine whether it's an HMO, and then you will need to come on to consider which area you're advising your clients about, because different local authorities have different rules. Just a few caveats. One is I'm only going to talk about England because in Wales the position is different. And secondly, why is it important? Well, your clients could face criminal liability and fines. There are stricter safety regulations. There's planning permission issues, which I won't cover. And finally, D should be that there are prohibitions on serving a Section 21 notice if you've got an unlicensed HMO. On the standard pro forma particulars of claim, you'll see that there is a section. It's a very long form. One of the sections is this an HMO? Is it licensed? And if you tick no, I think lots of alarms go off. So next, licensing. In essence, HMOs have to be licensed if they're occupied by 5 or more people who aren't a single household, and what I'm going to call a family. However, there is a difference, which is local authorities can introduce greater licensing if they want to. And I've had a quick look to see where I think your clients might fall. Wolverhampton and Solihull haven't introduced additional licensing. Birmingham is proposing to do so. They have had a consultation and they've asked the Secretary of State for permission. And Coventry has introduced additional licensing. And that was from the 4th of May, 2 years ago. So that means that in Coventry, all HMOs must be licensed. And that's an important thing to bear in mind. There's also selective licensing, which is where a local authority can decide to license rental properties that aren't even HMOs, but that's beyond the scope of this talk. There are a few tests. This is something that can be an HMO. The relevant ones for us are the standard test, the self-contained flat test, and the converted building test. The reason I say those are relevant is because this talk is focused on your clients who, as Harry said in his example, might have a small buy-to-let property portfolio. This isn't focused on anything beyond that. So I hope that's relevant. So, in essence, an HMO is something that follows these requirements. So it has to have rent, as you'll see at E. If it's a gratuitous thing where you've got friends staying or your clients have got friends staying, then it can't be an HMO. It must contain units of living accommodation that aren't self-contained flats. So in essence, that means it's got various bedrooms around the place and there's a kitchen and a living room. The living accommodation is occupied by people who are not a single household. So you might have friends living together, or I mean, that's going to be the most common scenario, really. It's going to be friends living together. That's going to be the classic example. Or if your clients have perhaps an HMO that has a lot of itinerant workers, people who have just arrived, people who have just come to the city because they've got a job. They might not know each other at all, but they're living together and sharing living facilities like bathrooms and kitchens. It must only be used as accommodation. And there's a lot of tortuous case law about whether, for example, a flat above a pub is an HMO. The answer is no. So you can be fairly sure that if your client is letting out property that's a part of a greater building that does something else, then it won't be an HMO. And two or more of the people that live there must share amenities. Right, moving on. The self-contained flat test is basically the same as the standard test, but it relates to a property that is part of another building, either above or below another floor in a building. And the converted building test is about a building that's been converted, and it's almost exactly the same test as the standard test. So in essence, that's what you need to be thinking when your client comes to you about any issue regarding their property empire. If they tell you, for example, oh, I've got 2 people living there or 3 people living there, that's only really going to apply for Coventry, that element, but you should be thinking about it anyway. Moving on, I mentioned the residence test, so it has to be somewhere that people are using as their residence. University students do count. So just the fact that university students go away for summer, Christmas and Easter doesn't mean that their university accommodation is not their main residence. It is. Refuges count, and property for migrant or seasonal worker does count. So this is going to be a key question for you to ask your clients. What's the relationship of the people in the property? Because the way I would think about it is the definition of family and single household is so restrictive that generally people are not going to be a single household if, as I say, it's friends or workers who have just come to the city for a short period of time. However, there is a list of single households or criteria, and you can see that here families, a single person, fairly obviously a single household, an employer and domestic servants. I don't imagine you'll come across much of that. A carer and care recipient, so they would be a single household. And just thinking that example through, your client could let out a 2-bed property, well, no, a 3-bed property in which there is a carer, somebody receiving care, and a third person. And that wouldn't fall foul of being 3 households, that would be 2 households. So you'd be fine there. And then there's a definition as to what family means. So family is a fairly comprehensive definition of what we all know, your relations, your parents, grandparents, brothers, sisters, etc. I'm not going to go through that list. Next. There are significant exceptions to the rules that make something an HMO. I've focused on the things that are probably the most important for you, which is this. If your client lives there as well with their household and up to 2 other people, then it won't be an HMO. So in this scenario, you could have your client living there, they could have a big family and 2 other people, and it would still not be an HMO. Now, the reason that's relevant is because you might have clients who are taking advantage of the government's rent-a-room relief. As you know, you can rent a room, you can rent 2 rooms, in fact, and get £7,500 tax-free. Now, that you can do that if it's up to 2 people. If it's more than that, then obviously you would be an HMO and you'd need to license yourself. And then the other example is the 2 persons household. So flat share or 2 unrelated persons, that's not an HMO. So there is this lower limit below which something isn't an HMO. And that might be a scenario you have that is quite common. Your clients may have a property, a 2-bed flat in the Jewellery Quarter, or a 2-bed flat in Wolverhampton or Coventry or somewhere like that, and that wouldn't be an HMO. Right, next. So, first point is, a landlord must apply for an HMO if it's the relevant HMO. And what that means is, the majority of the areas we're talking about, that would be more than 5 people. In Coventry, it'll be all HMOs, so more than 3 people or more. And that's a very important distinction to look up. And then the local authority has to make sure, before they give a license, that the HMO is reasonably suitable for the people who are going to live there. There are now statutory minimum room sizes. They need to be sure that your client hasn't been banned for running an HMO in the past. That there are sufficient management arrangements, which means somebody's not living in, the landlord's not living in Barcelona and ignoring his tenants. There's got to be some close relationship with an agent or whoever managing it on the ground. Got to be sure that the proposed license holder and manager are fit and proper people. And soon, but it's unclear when this is coming in, there'll be a requirement to ensure that the license holder has the necessary skills to run an HMO. Now, this is important. Well, 2 things are important here. Firstly, the license will impose conditions, and the conditions are all set out in Schedule 4 of the Housing Act. And those are conditions about safety equipment, furniture. The furniture has to have the right tag on to say it's not going to catch on fire in seconds. But this is even more important, I would say, for advising your clients. The licenses can last for no more than 5 years, and they cannot be transferred on sale. What that means is, of course, that if your client is going to buy a house to run as an HMO, he or she needs to apply for a license themselves. And also the license dies when the holder of it dies. So if your client is trying to buy an HMO that's come up for auction in a post-death sale, then they need to apply for a new license themselves. So it may be that you want to think, if you're doing conveyancing, to make the sale of the HMO or your client's purchase of it contingent or conditional on an HMO license being granted. Next, criminal offences. It is a criminal offence to run an unlicensed HMO or to manage it. And it's not strict liability because you can have a reasonable excuse, but in reality, it is pretty strict liability. And you will be liable if you are the person receiving the rent from the property or you're in any way managing it. Reasonable excuse, there are very few reasonable excuses, and the case law says that not knowing you should be licensed is not a reasonable excuse for not being licensed. Ignorance is no defense ever, but particularly in this case. However, you have a defense if you've put in an application. So what that means is if your client comes to you and says, I've got a 4-bed property in Coventry, you should be advising them very quickly to make an application, because if they make an application, then that's a defense to operating it unlicensed. It's also a criminal offence not to comply with the license conditions. So that means if you don't put in the carbon monoxide alarms, you don't put in the fire alarms, you have furniture which is highly combustible, you're committing a criminal offence. And as I've put at the bottom, there's no need to prove that the landlord knew, it should be an HMO. Importantly, and to speed up the process, since March 2017, the local authority has been able to apply to the first, they can impose a fine. They can just fine your clients, and then your client has the expense and has to take the time to appeal to the first tier tribunal. And then trying to tie this into our general theme, which is possession, you can't serve a Section 21 notice on a tenant while an HMO is unlicensed. So that is a significant thing to think about, particularly if your client comes to you and says, I've got a rowdy HMO, I've got problems. In fact, that was the very situation I saw on 24 Hours in Police Custody. It was a rowdy HMO. But if your client had an HMO and it wasn't licensed, he or she would not be able to serve the Section 21 notice. However, there's nothing to stop the Section 8 Housing Act route, 1988 Housing Act route, but that would take longer and you'd have to prove more evidence and so forth. You can also get, or your clients can also face, a rent repayment order. Now, these are for university students in Leeds. Their whole house was six students, which means it was sufficient to be an HMO. And one of the students decided not to get involved, but 5 of them took their landlord to court. The 5th is not in this photo. And they won a rent repayment order of £15,000. So your clients need to be very aware that this is something they could face. This article, this screenshot is from BBC 3 or Newsbeat, something like that. In essence, this got a lot of publicity with young people. And so I would not be surprised if there are more applications for rent repayment orders in the near future. What's next? This is a little bit of nuance, which is that all HMOs, whether they are licensable or not, are subject to these regulations, which are fairly toothless. What they provide is that the landlord must provide the tenants with their name, number, and address, or rather of the manager. And secondly, need to make sure that fire escapes are clear of any obstacles and kept in good order. But there's no real teeth to those measures. Oh, what have I done here? Okay. So I just thought we could work through I think, two examples. One is parents, and you very much might face this scenario. You have a client who wants to buy their daughter a house at university, going into second year. They want to move out of halls of residence, and your client wants to buy a house and let their daughter's three mates move in with her. Is it an HMO? Is it licensable? I'm not going to ask for answers, but the answer to the first question is yes, it's an HMO because it is. It's over 2 households, and it's a house, and all the other requirements would be fulfilled. They're obviously not a family. Is it licensable? No, because it's not over the 5-person requirement. But think about this: if one more person moved in, it would then be licensable, or if it was in Coventry, it would be licensable. So those are things to bear in mind. Now, as David said at the start, these slides are going to be available. So what I've put here is the local government guidance from Birmingham, from Wolverhampton, for Solihull, for Coventry, and I've also put some the ministry guidance on there as well. And I think that's it. Yeah, I hope that was interesting and useful. And I am, of course, available to answer any questions that you have about that.
Alex, Priya, Harry, thank you very much for those informative and densely packed presentations. We've got a few minutes left. I've got a whole bunch of questions that have been submitted over the Q&A, so I'm just going to choose a few. I will chuck those over to the appropriate speaker, having read them out. I'm going to start with a question from Lauren Smith, and she asks this. In terms of serving a EPC after the beginning of the tenancy to enable service of the Section 21, what about the position if the landlord did not have a valid EPC at the beginning? I see this happening a lot where landlords only become aware of the issue when I flag it. I suspect the answer is we simply do not have the answer. I suspect, Lauren, you're right. As Harry said, there's no direct authority on this point yet. And I've got two conflicting answers in my head. One is that if this ever gets anywhere, the court will just follow Trickerl and simply say, look, the policy behind this is not to just shut down the use of Section 21 forever. I mean, my personal reading of Trickerl is that it was essentially wrong on the law, but it has to be right in terms of the general wider policy. And I think to some extent that approach might be followed. However, I think with EPCs, it is distinguishable. In Trickerl, the Court of Appeal put a lot of weight on the fact that where you've got gas safety certificates, it's para 2.2 of the prescribed requirements regs, specifically disapplies the one timing element that you have with provision of gas safety certificates. So under para 6 of regulation 36 of the gas safety regs, if you just read it naturally, it says that the certificate has to be supplied within 28 days, and that's the timing element. And then Reg 2.2 of the prescribed requirement regs removes that. So you're left with a requirement that has no, and this was the finding in Trickerl, has no requirements in terms of timing. The temporal element has gone. There's no equivalent to that for the EPC regs. There's no removal of the temporal element. And what the EPC regs say is that you have to supply the EPC to the person who will ultimately become the tenant. Now, it might be seen that therefore is a temporal element to the requirement to supply an EPC, with the element being it has to be supplied to a person before they become the tenant, and there's nothing disapplying that temporal element. So on the basis that the Court of Appeal relied so heavily on Reg 2.2 of the prescribed requirement regs, and there isn't an equivalent with the EPCs, maybe there will be a stricter approach if you get either a High Court judge or a Court of Appeal who doesn't like the idea of Section 21s being used more freely. But really, it could go either way, I think. So I'm sorry, Lauren, that that's not a very clear answer. But the point is there isn't one, and that is useful to know, I think. I want to just then move on to another question from TT, which is simply, can you run Section 21 and Section 8 in one possession case as an alternative? And that really flows from what I was saying previously, which is that perhaps if you've got the simple answer is yes, you can, as long as you're not going down the accelerated possession route. But I think the importance of this is really a little further down the line, which is what happens if you've got a client who has just issued Section 21 proceedings and you identify that actually there is a potentially fatal flaw with all of this. And the approach that I tend to suggest we take, especially if there are rent arrears, if there's some basis for using Section 8, is to just get the notice served and get proceedings issued as soon as possible under the Section 8 notice. And then either at the first hearing of the Section 8 claim or at some directions hearing, if there is one on the Section 21 ongoing claim, just apply to consolidate it all together. And it might not get you too far in the grand scheme of things, but if you can consolidate them and your Section 21 claim is doomed to fail ultimately, but no one's really picked up on that yet, you'll at least have some costs protection, because you might end up at least with a possession order on the Section 8 claim. And you can say, look, we won the entirety of the proceedings. The fact that the Section 21 never really went anywhere, well, who cares? We still should be entitled to our costs. It's at least better than just discontinuing or losing the Section 21 claim, especially if you've got a represented tenant on the other side. We've then got an anonymous query. There are agencies that require 12 months upfront payment or 6 months upfront payment. Would that be considered a deposit? Priya, what do you think about that?
I think my question would be is how it's termed within the tenancy agreement in the first instance. Is it actually an advance rent, as we discussed at the beginning of my part of the seminar? So is it to discharge an obligation on the tenant, or is it a sum of money that will be returned to the tenant at the end of the tenancy? Depending on that, then whether it's an obligation or it's security. If it's security, it will need to be protected.
I think it was in Johnson and Old where the court gave basically the acid test for this question, which is that if following an arrangement where there's perhaps an advance rent payment or something like that, if the landlord went to the tenant and demanded rent during the period where potentially there's an advance rent payment still being discharged, if the tenant tells the landlord, well, bugger off, I've already paid the rent, then that tends to point in the direction of it being a legitimate advance rent payment rather than a deposit. Whereas if the tenant says, oh yes, of course, here's the rent, I just happen to know that it's secured by way of some deposit in the background, then it's going to be a deposit. And that really is the question that the court is answering in those sorts of cases. TT's just come back on the answer I gave, which is whether in terms of Section 8 and Section 21 parallel proceedings, can we amend rather than consolidate? So I assume we've issued the Section 21 proceedings, we then serve a Section 8 notice, that becomes usable, the deadline has expired. Can we then amend the Section 21 claim to now plead the Section 8 notice and rely on that. I've certainly seen it done. I don't tend to advise doing it for the simple reason that your cause of action that arises from the Section 8 hadn't arisen at the point that your proceedings were issued. And I tend to think that you shouldn't be, if there's an alternative mechanism, you shouldn't be amending claims to rely on causes of action that didn't exist at the time that the claim was issued, and that the appropriate way forward there is to issue a new claim and consolidate them together. But I know there's difference of opinion there. And as I say, I've seen it successfully done in terms of just amending. It really depends on the judge you've got. Whereas issuing and consolidating, I think you've probably got a better shot, except it's obviously more expensive and potentially time consuming. Right, I think we're at just about past now. So unless any of the other panelists had anything to add to to the answers I've just been giving, I appreciate I haven't brought in Harry on that EPC point. I don't know, Harry, if you had any views on that.
No, I'd just echo what you say. I think it would be a brave decision to run that argument, as you say, which does exist. I think it would be a landlord that would have to be prepared that there may well be an appeal that followed. It may just be the case that the simplest way of going is to go the Section 8 route, but that, of course, assumes that there is a ground that one can rely on. So, no, I completely agree with David. I appreciate, Lauren, that you're probably in somewhat of an impossible position on that one when there are no grounds. But unfortunately, we don't have an answer for you. I think what might be interesting to see is if an answer does come along, or if the Section 21 route will be abolished before then. But we'll have to wait and see, I'm afraid. But no, David, completely agree.
And
David,
Alex,
I just have a short point to make on the EPC matter. I had a case where a client of mine had, again, a small property portfolio. The majority of his buildings were listed, and so this particular property he thought was exempt from requiring EPC certificates. So he thought he had gone through the correct procedures and was essentially exempt and didn't need to file an EPC before serving a Section 21. It turned out he did. He then obtained an EPC, but it failed the EPC. It was a fail. And he relied on that EPC as a valid EPC. And the court found that because it had failed, it was not a valid EPC. And so he couldn't serve a Section 21.
Interesting. Okay, thanks for that, Priya. Alex, did you have any pearls of wisdom to throw into these points?
No, thank you. I think you've covered everything I would have said.
Perfect. Okay. Well, everyone, thanks for attending. Thank you to the speakers. Our main property conference is coming along in July. That's going to be in person. That's on the 1st of July. So I hope to see some of you there. But apart from that, again, thank you for coming. And I'm going to call it an evening now. So thank you and goodbye.